Good afternoon, everyone. Maybe I'll move to the camera. So, welcome to the RDA webinar. First of all, I would like to inform you that we will record this webinar and make it available via the RDA website and via YouTube. Your questions and discussions will not be published, so you will stay completely anonymous if you write something on the chat. If you have any questions, please type them into the chat window at any time, and they will then be addressed at the time where we have the questions. So thank you for attending. My name is Irina Kupiainen from RDA Europe, and today we have in this webinar as our guest member of European Parliament, Julia Reda. I will give a brief introduction. Julia Reda was elected to the European Parliament for the Pirate Party in 2014. She is a vice chair of her parliamentary group, which is the Greens, European Free Alliance. In the European Parliament, she serves as a coordinator for the Greens and European Free Alliance in the Committee on Internal Market and Consumer Protection, and as a member of the Legal Affairs and Petition Committees. She co-founded the Digital Agenda Intergroup in the Parliament, and her legislative focus is on copyright and internet policy issues. In 2015, Julia Reda was responsible for the Parliament's evaluation of the Copyright Directive, and she will be the Green Shadow Rapporteur for the copyright legislation. So we will first hear Julia Reda's presentation, and afterwards there will be time for questions. So please type your questions in the chat as was instructed. And now I would like to give the floor to Julia Reda, please.
Thank you. I'm really glad that there's such an interest from the research community in what we're doing on copyright reform. I think that the lion's share of the recently proposed proposal on the copyright reform from the European Commission deals with questions around research and education. It was already quite an important theme in my report on copyright that the European Parliament adopted last year. And since then, we have been waiting for a long time for things to actually happen, because it has become clear over the last years that there are a lot of problems with the way that the copyright regime works for research and education, particularly in a cross-border environment when researchers from different countries in the EU are trying to collaborate on subjects, when students are participating perhaps over the internet in studies in other countries. And the good news, I would say, is that from the proposal that the European Commission has brought forward on the 14th of September of this year, there has been a real attempt to make some progress in this area of research and education. And I think after having witnessed for several decades that copyright law has only ever gone in the direction of restricting access and generally making the situation more difficult, that there is really a recognition that at least in the area of research and education, we do need some flexibility in copyright. We need exceptions and limitations to copyright that actually also work in an international and in a cross-border setting. But in a way, this is also where the good news ends, because when we are looking at the details of the copyright proposal, this is really where the devil is. And I would like to, first of all, introduce the most important provisions of this new copyright proposal as they relate to research and education, and point out some of the problems of these proposals that we will be addressing in the legislative process in the Parliament, in the Council, and finally also talk about what you can do to influence this process, because I think we're really dependent on expertise from the academic practitioners who have to work with these rules that we're writing in real life, and who can probably tell us what kinds of rules are likely to work or not to work. So I think the most reported and most well-known element of copyright for research and education in this new copyright directive that the Commission has proposed are a number of new exceptions to copyright that are supposed to have a cross-border effect and be mandatory for all European member states. So the first one is the exception on text and data mining, which is something that already exists in the UK to a certain extent, and where also I think the experience in the UK has led to quite an interesting discussion that we already had around my copyright report last year. But unfortunately, in some respects, the proposal made by the European Commission is more narrow than what the European Parliament had in mind when it adopted my report. So in the discussions in the European Parliament, there was at least a recommendation that such an exception should apply to research purposes. We had seen that with the UK exception, which only applies to non-commercial research, that sometimes the distinction between commercial and non-commercial is quite difficult to make. And the European Commission has recognized that and therefore not included commercial, non-commercial as an element in this proposal. But what the Commission has included as a limitation is that it has defined the beneficiaries of this copyright exception. So unlike the UK exception for text and data mining, which applies to anyone who is conducting non-commercial research, the proposed exception by the European Commission only applies to research institutions. And I think this is also a potential problem because it means that whenever a researcher wants to rely on this exception, they will somehow need to act through their research organization, through their institution. And then the question is not whether the particular use that the researcher wants to make of text and data mining qualifies under this exception or not, but what matters is what kind of organization is he or she affiliated to. And particularly for citizen scientists, for PhD students who may not have this strict institutional support, this may pose a hurdle. And of course also for any research that is done outside of research institutions in the stricter sense, so for commercial researchers working in companies. And my personal perspective on this is that it's rather an accident that text and data mining is treated as a copyright infringement in the first place, because unlike other acts of exploitation of copyrighted works, it's not about using a particular work that has an intellectual or artistic merit, but rather is extracting fact from a large body of information. So my hope is that in the European Parliament we will limit these restrictions, particularly regarding the beneficiary organizations of this exception. Another limitation, or well, limitation is perhaps the wrong word, but another issue with the way that this exception has been drafted is that it allows academic publishers, so the rights holders of the content that might be mined, to put in place measures to protect their networks. This kind of stems, I think, from the complaint from many publishers that if they just allow people to do text and data mining on their own terms, they will download a large number of articles, and this will put an unreasonable strain on their servers. I've even been told by one large academic publisher that this might mean that doctors in the emergency room will not have real-time access to academic papers while they're operating on somebody, although I hope this is not actually how the emergency room works, but to some extent these kinds of arguments have been successful, and I'm concerned about this limitation of the exception, because it's very difficult to prove if somebody is trying to limit your right to do text and data mining, for what reason they did it. It's very easy for a rights holder to claim that they were doing it in order to protect their networks, when in fact they just want to limit your ability to do text and data mining. So I think this is also something that where our our political debate will be very much dependent on your experience, like to some extent or to what extent researchers face hurdles from publishers when they're doing text and data mining today. Because if we have the expectation or the experience that generally publishers are not facilitating text and data mining, then of course it's a bit contradictory to put into place a provision that can help them to more or less make the text and data mining exception less useful. Then there is also a new exception that has been proposed for the purposes of illustration for teaching. And I don't know to what extent the viewers of this webinar are engaged in teaching in academic context, so I will keep it brief, and if you have more questions about it, feel free to also ask so at a later point. But basically, this new exception has cross-border application, which means that if you are allowed to use particular material in the classroom in a digital form, then you should also be able to use it in a digital form in cross-border settings. So, for example, if you have students participating remotely. And unlike some of the education exceptions in the member states, it's quite broad in terms of the subject material. So it covers any kind of material that may be useful in the classroom context. I think the main problems with regard to that one is, first of all, that the proposal leaves it open for member state to override this exception with the availability of contracts or licensing agreements that are available on the market. So in other words, it's possible to continue to have a system like we have in Germany, where a publisher can simply say, well, we have a licensing offer, therefore the exception does not apply. That I think is probably leaving a bit too much possibility to individual publishers. And perhaps one thing that we could discuss instead would be to say, okay, a member state can keep in place an extended collective licensing agreement like some of the Scandinavian countries have, but we do not give the possibility to every single publisher individually to override this exception. Another issue also with regard to this exception is how exactly the compensation should be regulated. I think it's probably unlikely that we're going to end up completely without compensation in all of the member states, but nevertheless there might need to be some European guidance on how this compensation should work if it exists, because again, in Germany at the moment we have the problem that the collecting societies require professors to indicate every single individual work that they upload, for example, to a digital folder for their students, and that thereby the transaction cost of actually using the exception and calculating the compensation becomes so high that using the exception is not attractive anymore. And so one possibility would be to put into this proposal that if there is a compensation, it shouldn't be done on the level of the individual work. Other than that, there's a third exception that is new, which doesn't apply to researchers directly, but may nevertheless be important to them indirectly, because it allows museums, archives, and libraries to make copies of their own collections. I think this should be a matter of course, but it will hopefully allow the possibility to also make a better preservation of particularly digital works that may also be the subject of your research. The only problem is there that it doesn't at all go into the question of making available. So it only says that these libraries and archives should be able to make copies of works in their own collections, but arguably in the absence of any making available clause, they will still not be able to show them to you until the copyright has run out. And there are some provisions in place in the copyright directive from 2001 that I think are very outdated by now. For example, when it comes to the possibility for libraries to make things available on dedicated terminals inside the libraries, when today you will probably much rather want to use your own device, like your own smartphone or tablet or anything like that. So I think, yeah, it's not a bad provision, but at the same time, it's also so limited that we should perhaps think about how we can extend it. On top of that, there is a proposal for extended collective licensing for out-of-commerce works. I think this is also particularly interesting for the humanities, but also for history, for political science, because you have a lot of copyrighted material that is available in museums and archives that cannot be digitized because it still has copyright, even though there are no rights holders who are actually looking out for any kind of commercial exploitation of these works. I'm thinking about things like political posters or buttons, leaflets, things like that, that have no commercial value anymore, but that may be of huge academic value in terms of research. And unfortunately, this extended collective licensing provision, as well meant as it may be, the way I read it, only works if there actually is a collecting society that is representing the authors of this particular sector. And so it may work to an extent for photographs, for books and possibly films, but precisely not for the kind of material that is currently in a kind of limbo where nobody really knows what to do with it. And a lot of those works are also orphan works, so technically there already is a possibility to make these works available by registering them in the existing orphan works registry. But there, our experience has been that very few academic institutions and libraries can make use of this possibility because the cost of doing the diligent search for the rights holders is too high. So when we think about a good provision for out-of-commerce works, we should make sure not to repeat these mistakes, that the diligent search does not become so burdensome that at the end of the day, the kinds of works that are supposed to be covered by this out-of-commerce works provision are falling out of the scope. I mean, if you have hundreds of political leaflets, you're probably not going to be able to make that investment. So this is kind of, I would say, the positive side of the proposal. I would just briefly like to also point out two things that could produce additional burdens for researchers or raise new problems. The one is the so-called neighboring right for press publishers. This neighboring right is quite unclear and quite wide in its scope. And it introduces a new layer of protection to press publications, whereas press publications are supposed to cover any kind of periodic publication, either online or offline, as long as it has some level of journalistic content. And now I'm wondering, for example, if you have an academic journal that has an editorial that is journalistic, whether this would fall under this new neighboring right or not. And if it does, I think this would have huge implications for research. But in general, there's also simply, from my perspective, no need for this new neighboring right, because the content that is covered by copyright protection is already available, or there is already an exclusive right available that publishers are exercising. I mean, most of the time, it is not the individual authors who are going after copyright infringement, but rather the publishers. And for those parts that are not covered by copyright, for example, because they are not an individual and intellectual creation, but rather simply collections of facts, there's a good reason why there's no copyright protection there. So this new neighboring right is also supposed to apply retroactively for the last 20 years. So this raises the question whether existing publications that you may have on your website, basically your own publications that may be linking to other content or including other content, whether this might come into conflict with this new legislation. Another thing that is quite controversially discussed is a new provision that would require online service providers, online platforms where users can upload content to introduce content identification technologies. I think this the effect on research is perhaps more indirect in the sense that it is making the effective use of the copyright exceptions less relevant, because one effect that we are seeing of this content recognition technology is, for example, on platforms such as YouTube that are already using them, is that copyright exceptions are usually not taken into account. These are algorithms that find out whether a particular content is identical to the licensed content of a rights holder, and if it is and there's no license, it gets taken down. But of course, this technology has the underlying assumption that everything that is not licensed is a copyright infringement. And I think particularly research and education is an area where this is not the case, where you are allowed to use, for example, small parts of a recording or a video or a picture in a video of a lecture. And this may invariably get taken down simply because this technology is not able to recognize copyright exceptions. So this is also something I think to look out for researchers, particularly if you are putting videos of your lectures online or activities like that. So to summarize, I think you can see from the proposal that the interests of the research community have been better taken into account than in previous proposals. There are some elements that are particularly aimed at making life easier for researchers, but I think still the proposals need quite a lot of work to actually achieve that goal. And the academic community, also the library community, I think has become more effective at communicating the needs that they have to legislators. But at the same time, there are still some problems in this regard. So, for example, we get a lot of very accessible, very shiny lobby material from industry groups. And we quite often, the academic evidence is available, but it's not actively provided to us. It's not pushed to us. And if it is, it's often quite inaccessible in the sense that, well, in order to make an academic argument, you have to kind of lay out that argument over many pages. There may not be an executive summary or things like that. So I think there is definitely an argument to be made for making sure that the evidence that you collect and your own expertise about how copyright is interacting with the research process, that this material is also made available to policymakers in order to make it easy for them to do the right thing and to take researchers' interests into account. I will leave it at that, and I look forward to your questions.
Thank you, Julia Reda, for the excellent presentation and excellent summary on this proposal. I see that there are some questions here. However, I might ask a few questions here first that are more maybe on general level. Mm-hmm. I was going to ask about your view on the strengths and weaknesses of this proposal, mm-hmm. but I guess they were quite well already summarized in your presentation.
Yeah, perhaps as a general point, mm-hmm. I think the strength is definitely that there are a lot of proposals aimed particularly at research and education, and the weakness is that every single one of these proposals has the potential to actually make things worse, because none of them are really clear in the sense that they say text and data mining is allowed, full stop, or this exception for research applies across the board, no licensing override or anything like that. There's always a provision that somehow makes the picture less clear. And so I think every single one of these provisions for research and education will need to be changed and will need to be improved.
Yes, that is to some extent an observation that we have also done in our community, more or less. The Research Data Alliance is a bottom-up initiative that is all about creating common policy standards and practices for data sharing and reuse. And which means across borders, across scientific disciplines, but also across the public and the private sector, to enable the data actually to be used freely and to move freely between the sectors. So how do you see that? And this is clearly, I mean, stated in many EU strategic positions that this is beneficial for the society and for Europe's competitiveness. But how do you see that this proposal, does it support this kind of thinking?
I think it does support to an extent the sharing of information and of research across borders. What it doesn't touch at all is the interaction between the public sector and the private sector. I mean, I think it's great that the Commission is trying to improve the situation for the public sector at least, but quite often the distinction is not so clear-cut, and there's, I think, the reason why, for example, private companies have been left out of the text and data mining exception is that there is a fear that whenever we actually do improve the situation for companies who are using copyrighted content, that this will go somehow unilaterally to the benefit of American multinationals rather than European companies. And I think this is, in a way, a self-fulfilling prophecy. If we don't create the possibilities for European research companies to actually reuse data that they have already paid to access, then of course there will not be a lot of development in this sector in Europe. So I think when it comes to actually improving the possibilities to do text and data mining for commercial purposes, this is something where also it doesn't fit with the general claims that the European Commission has made, because we must not forget that this proposal is part of the digital single market strategy. So the market part is missing, more or less.
It is interesting. Maybe in some discussions it has also occurred, and you maybe referred to the text and data mining, and maybe that it is not so well known as a method, and it might raise some worries in commercial actors. And do you think that this could be somehow clarified and somehow made aware of what it actually is, and that it is in a way very technical method that is enabled to be implemented so that it doesn't endanger the commercial rights?
I think one way that we have tried to clarify it, and I think quite successfully in my copyright report last year, is that we included the provision that it only applies to lawfully accessed content. So this means that if a rights holder wants to keep their content locked up and only give access to it in exchange for money, then they can continue to do that. And that, in fact, text and data mining does not overwrite the exclusive right in deciding how your content is used or not. It's only saying, well, if you grant access to this content, then it's not just the right to read this content, but also to use the help of a computer in order to automatically read and analyze this content. And I think then it shouldn't matter whether it's a commercial company or an individual researcher who is doing this. But in the current proposal, neither the individual researcher nor the company would be able to benefit from this exception.
Yes, so these are clearly some points that should be clarified in the work or the process where you now are in with this proposal and to enable these things. We could maybe now look into the questions that we have here. We have a question about on what legal basis would you want to force publishers to make information available at what bandwidth?
So first of all, the legal basis of the proposal is Article 114, the internal market. So clearly, this is the legal basis that all of the copyright legislation so far has been done. And I think about the question of the bandwidth. I think there is simply no need for a specific provision that says that rights holders can limit their bandwidth inside a copyright exception. I mean, that really doesn't make any sense to me. Either the bandwidth is available, then the bandwidth is available regardless of whether somebody is conducting text and data mining or using the content in some other legal way. So my concern is simply that this provision is going to be used as an excuse for limiting completely legal and legitimate text and data mining under the guise of not having enough bandwidth. Of course, that doesn't mean that a publisher will suddenly have to provide higher bandwidth. It's just that they're not allowed to artificially limit it for that particular purpose.
Okay. Next question is about I think this is text and data mining. So do you think that compensation should be paid for the text and data mining exception?
No, I think text and data mining is mostly application of the concept of reproduction. I mean, I think usually or initially the reason why our copyright system is based on this concept of the reproduction is because it's easier to go after somebody in the analog world if already making 20,000 copies of a book is illegal. If you have to wait until they're actually starting to sell those copies, then of course this would be a lot more difficult. The problem that we're seeing in the online world is that digital technology, by its very nature, requires some copies to be made that are not at all intended at being distributed to anybody else. This is why we already have the mandatory exception for temporary copies that are part of the technological process. The problem is that it's very difficult to make efficient and reproducible text and data mining by simply using this temporary copyrighting exception. So for the purpose of text and data mining, it should be possible to make those copies for a slightly longer time in order to be able to analyze the content better. But it is not a new form of exploitation of that content. It's only the extraction of facts, and facts themselves are not covered by copyright. So I think if we manage to form a clear exception that says that text and data mining is allowed, that the right to read is the right to mine, then I think this is a helpful clarification. But if we make too many qualifications to that, saying, you have to pay compensation, and by the way, it only applies to research organizations, we're rather limiting what is already allowed than improving it. So, for example, in the Netherlands, the District Court of Amsterdam already ruled that a rights holder is not allowed to forbid the text and data mining of somebody who has lawful access to the content, because that would be a violation of the freedom of research. So I don't see there's any grounds for asking for a compensation.
Isn't it so that in the US it is more or less similar to the UK in terms of
in a way, in a way, yes. So the UK has a specific exception for text and data mining for non-commercial purposes. The US has the fair use doctrine, which takes into account a number of criteria when deciding whether a particular use constitutes fair use on a case-by-case basis. And one of those elements is also the question whether use is commercial or not. But that doesn't mean that in the US any commercial text and data mining is automatically forbidden. And in that way, I would say that the US provision is a bit more a bit more or a bit less restrictive than the UK one. There are also other examples. For example, Japan has a text and data mining exception, which includes commercial uses and is also applies to any material without any compensation requirement.
Okay, so there are clearly some references from other countries on how this could be implemented. So let's hope that these barriers that we have here are able to overcome those. Okay, some more questions. So here's one more on the text and data mining actually here. So is text and data mining allowed for educational purposes?
I think at the moment it depends on the member state. Clearly, it's possible under the InfoSoc directive to allow text and data mining for educational purposes under the optional exception for research and education. I don't think that the new Commission proposal for the harmonized education exception is going to improve that situation because it only applies to illustration for teaching. But it's important to note that these new mandatory exceptions in no way override any of the existing optional exceptions. So even though, for example, the UK text and data mining exception applies to individuals, and the now proposed EU text and data mining exceptions applies to institutions, my understanding of the directive is that the UK would not have to limit its existing exception because that was made under the optional exception in the InfoSoc directive, which continues to apply. So in the same vein, member states are already able to allow text and data mining in the scope of their education exceptions. Unfortunately, the text and data mining exception by the European Commission, I would say, doesn't, at least not obviously applies to schools, because it applies to research organizations and then also to organizations that have a mixture of research and teaching. But if you have a school which is not engaged in research at all, at least there's a real danger that it would not fall in the scope of this new mandatory exception.
Okay, so this is really has a lot to do with how to actually scope these exceptions and how to define them, and clearly there seems to be a need for these definitions in many areas here. There's also one comment that actually we more or less already covered, but so that basically the issue of how to engage industry and how to get the benefit out of the data on a wider scale, and here we have a comment which states that it is problematic for researchers also from the point of view as funders encourage collaborative research activities between higher education institutions and small and medium enterprises, for example, in Horizon 2020.
Well, there is, at least as regards the text and data mining exception, there is a recital that says that public-private partnerships between universities and industry should be able to take advantage of this exception. But then I really have to wonder why they should be allowed to benefit from the exception, but an individual researcher who is not affiliated with an institution should not. So I think there's on the one hand, I think clearly they try to take account of this because, well, you can't have a research policy on the one hand that encourages collaboration with industry if at the same time you have a copyright law that discourages it. But I think it has led to some contradictions where I really have to wonder from a public policy perspective, okay, why should we give this privilege to public-private partnerships but not to individual researchers?
Yeah, that is a good point, definitely. There was one question here. What kind of risk does an institution expose itself to by publishing out-of-commerce works? In other words, what are the potential legal consequences if an infringement claim is made at a later stage?
I think if the proposal by the European Commission is implemented, there would not be a risk for the institution itself if it has gone through the steps of establishing whether a work is out of commerce. This proposal foresees a possibility for rights holders to, at a later point, identify themselves and opt out of this extended collective licensing scheme. But I have to say that the details of that are not at all clear. In the impact assessment, at some point, the Commission was even directly referencing the diligent search in the Orphan Works Directive, which I think, well, places quite a high burden on institutions that are that want to use orphan works or that may want to use out-of-commerce works in the future. So it's not really clear whether there's going to be a database of these out-of-commerce works or whether it will simply be up to the collecting societies. But then I have to wonder, what about rights holders of content that is not represented by a database? I think, or that's not represented by a collecting society. And what I find curious is that the Commission, in its impact assessment, did not even consider the possibility of an exception in this area, which is weird, because this was actually the preferred option of the libraries and archives that they expressed in the public consultation on copyright. And if we were to go in this direction, it would be possible perhaps to also deal with out-of-commerce in a similar way as the Commission is dealing with teaching for illustration. So to say, okay, there is an exception unless there is a collective licensing scheme in place.
Okay.
So it's a difficult question to answer, because I really don't think that the out-of-commerce provision is going to stay exactly the way it is right now, because the way it is now, it's very unclear what exactly would change because of that. Probably not much. It doesn't even clearly say that every member state has to put in place such an extended collective licensing scheme. So yeah, it's very unclear. And I think we also will have to look at the outcome of the European Court of Justice case on extended collective licensing that I think is supposed to come this week.
Ah, okay. Okay, yes, that will be interesting to look into. So, question regarding the instruction exception.
That's a teaching for illustration, I think. Illustration for teaching, yes.
Think so,
Yeah.
yes. So it says here, the problem for people in the UK is the potential for the changes to limit any uses under the exception to those licensed. Currently, we can override any licenses to use the exceptions. This could potentially increase teaching-related costs significantly. We can, of course, rely on other exceptions.
Yeah, I agree. I think this is a true risk, and the best way to avoid it would simply be to delete the provision that says that member states can decide that a license overrides this proposal. I mean, of course, at the end of the day, it's up to the UK government. Nowhere in this exception does it say that, or the UK Parliament, nowhere in the exception does it say that a member state has to grant a precedence to a license. But of course, I think it was a huge step in the right direction of some member states to prevent any contractual override of exceptions. And so it's, I think, at least dangerous for the European Commission in one of the mandatory exceptions that it proposes specifically for the purpose of improving cross-border access and making sure that there's the same conditions everywhere, to then say, okay, but member states are allowed to grant a contractual override of those exceptions. That really doesn't make a lot of sense to me. And I think the main reason why they did it is because they don't want to completely change the extended collective licensing schemes in the Nordic countries. But I don't think it's necessary just in order to preserve the ECSL schemes in the Nordic countries to say that any license or any publisher can basically make the exception not work for them specifically just because there is a license.
Yeah, exactly. Yeah, also there is once again point on the text and data mining and about it being only partly helpful to researchers because the mining activity is only one part of the research, and so what about the publishing the results part? And
well, I mean, it depends really how exactly the results are published. I think it should be possible, for example, to publish, first of all, the script with which you have done the text and data mining and to reference exactly what version of the content you have accessed. And of course, it's also possible to publish small extracts of the text that are not long enough in order to qualify for copyright protection, unless the neighboring right for publishers is introduced. Because if that covers whatever you are mining, then you will no longer be allowed to publish snippets that may be the results of your text and data mining. So I think it is possible to, if we don't introduce the neighboring right for publishers, to have a text and data mining exception that may not allow you to publish the entire body of content that you have mined, but that nevertheless allows you to publish the snippets that you found that by themselves are not protected by copyright, and for you to make it transparent how exactly you've extracted them from the text so that other people who have lawful access to their content can reproduce them. So this would be, I think, the way that we should go about this.
So do you have any thoughts on if an option should be created to store content that was used for mining but to which only temporary access existed?
Yes, I mean, I think at least the researchers themselves should be able to make local copies of their the material that they want to mine. They may not be able to then make these copies available to others, but at least I think for them to be able to reproduce their own research, that should be the requirement. I mean, in the same way as in the analog world, if you buy a magazine, you are allowed to keep that copy.
Can you elaborate a bit on the interaction or the relation between the database right and copyright, and does use under the text and data mining exception overcome any database right issues?
Yes, the text and data mining exception proposed by the Commission explicitly is also an exception to the sui generis database right in the database directive. And I think that's very important. If you don't do that, then it's almost useless, at least to the extent that rights holders are actually making use of the database right. At the same time, the European Parliament has also called for a review or even an abolishment of the database directive because they don't think it has really worked, especially considering that some databases are anyway already protected under copyright. So we will have to see whether the Commission is going to follow up on that, but at the very least, you can say that the Commission is aware of the fact that also database rights and not just copyright may limit your ability to do text and data mining, and therefore they've made it explicit in this exception that it applies also to the database right. But of course, that means that whoever is not in the scope of this exception will continue to have problems. Like, for example, if a member state has a and text and data mining exception that is done under the optional exceptions in the InfoSoc directive, then this will not apply to the database, right? At least not automatically. You would have to find an optional exception in the database directive. And there, I think the provision for research and education is more narrow than in the InfoSoc directive. So therefore, I think just in order to keep it simple, it really doesn't make sense that one member state ends up doing their text and data mining exception under InfoSoc, and then another one only does what is required under this new mandatory exception, but rather to have one text and data mining exception that covers everything.
Yes, yes. So does the definition of cultural heritage institutions in Article 2.2 include universities or their university libraries?
I'm not sure. I would have to look that up. But it's definitely something to look at to make sure that. I think any too prescriptive definition of cultural heritage institution is probably going to be harmful, because of course cultural heritage institutions also change in kind of exactly how they are constituted, and
So there was one question, and that is actually something that maybe brings us back already to the question of how the research community, or how the library community, or the whole RDA community could help here, and what we could do. And you already referred to the awareness raising, the importance of good statements and materials, and I believe that this is something that is more or less realized in the communities, and there are some efforts, but at the same time, of course, we have noticed that this is particularly challenging issue, and there are many interests involved, and therefore, of course, it would be great to hear from you also some maybe helpful ideas on what we could concretely do, and what researchers what would be the best way to influence this.
I think first of all, there are three major institutions who have a say in this. That's the Commission, the Parliament, and the Council. And I think all of them have their role to play, and all of them are also potential addressees of academics and their expertise. So on the side of the European Commission, we have the somewhat odd situation that we have one commissioner who has presented this proposal who is most likely not going to continue, because Commission President Juncker wants to appoint Commissioner Oettinger as the new budget commissioner, which means that we would have a new digital commissioner. And there have been at least rumors that this new digital commissioner might be Carlos Moedas, the current research commissioner, which I think probably from the point of the research community would be good news, in the sense that he already has an understanding of research issues. But I think at the same time, from now on, the Commission's influence on how the proposal is going to progress will also be limited, because their main role is initiating the legislation. And they will, of course, participate in the negotiations between Parliament and Council and propose compromises and so on. But at the end of the day, it's the Parliament and the Council that will have to approve the proposal. So I think this is then also where researchers should focus their energy. One thing that has been quite successful, for example, is a number of researchers who are working on questions around intermediary liability from all over Europe have gotten together and written a letter to the chairs of the relevant committees and also to the European Commission about this content filtering technology. And I think similar things could be done about different provisions in the proposal. If there is an academic consensus that a particular problem exists that is not sufficiently addressed, or if there's an academic consensus that one of the provisions might be harmful, that actually these academics get together and express that in some formal way towards the rapporteurs. So these are the people in the different political groups who are in charge of negotiating the file. There is, I think there's never enough attention paid to the council, especially from the public sector, from civil society. So certainly seeking the dialogue with your national justice ministry or culture ministries or whoever is in charge of copyright is very, very helpful, so that they also are aware of the specifics or specific problems that may be particular to their country, that should at least not be made any worse through these proposals. So I'm thinking, for example, there's certainly a lot we can learn about the current problems that exist with the compensation for educational or digital copies in German universities. In the European Parliament, there's a relatively small number of MEPs who will really be leading on this file. There's the rapporteur, Therese Comodini-Cachia from the EPP in Malta. So she will be the main person drafting the Parliament position and then negotiating with us shadow rapporteurs. And aside from her, the largest the second largest political group is the Socialists, where it will be Lydia Geringer de Odenberg, who has also been the rapporteur for the Orphan Works Directive, so she's also not entirely new to this subject. And so the names of all the shadow rapporteurs will shortly be made available also on the Parliament website. And so these would be, I think, the main people to get in touch with if you have any particular concerns about this proposal. And on a more general note, I think it's also important to publicly speak about this. Like, for example, in Germany, with the problems that exist currently with the compensation for educational uses, is they have very real consequences, in the sense that students are suddenly having to go to the library again and make photocopies of works that up until now they were able to access online. And some of the students in Berlin, for example, have been staging a protest in front of the collecting society responsible for this. And I think kind of reaching out to the broader public, especially if you have issues that directly affect students, I think is a very, very helpful way of also bringing this beyond kind of the merely professional research community. I think there's a much wider research and education community that also includes the students. That should definitely be involved and be informed about what is at stake in the European reform.
Excellent points, and very, very helpful information, I'm sure. And maybe also related to this, what I'm interested in is the what is the time scale here now? So what is the best time to influence, and how will this proceed? How will this process go on now?
Well, when he presented this proposal, Commissioner Oettinger said that he wanted the European Parliament to vote on the copyright directive next summer. I think that's completely unrealistic. I mean, if you look at previous copyright files, the discussions took a lot longer than that. But I think that bringing entirely new concerns to the table is only going to be successful if you're there from the beginning. Because what may be possible, or what we have seen sometimes, is that if there is a really harmful provision and there is a public protest against it, so for example with the ACTA treaty a few years ago, it can be possible to stop a bad provision even at relatively short notice if there is enough public attention to it. But I think it's much less possible to effect any kind of positive change if you're not basically working on the topic from the beginning and providing your perspective and providing the expertise. So I think the time to get active on this is really now, even though I don't think we're going to vote in the summer.
Yeah, okay, but I'm sure that you're right in taking a very comprehensive view on this and trying to address the different actors that are involved and in doing it in a good time, because there are, of course, many other actors here on the field who are also doing their own influencing work, and this is something that should be taken into account, and really maybe try to focus on how to raise the awareness and how to get the voice of the academic community to be heard in these issues. Let me see if I have any more questions here. I think we have now more or less covered all the questions and all the topics that were on our mind, and I also see in the chat that people are happy and they want to thank you, and yes, the recording will be available, and so maybe I want to also show my face, and I would like to thank you, Julia Reda, for taking this time. This was really a valuable opportunity for us, and on behalf of all the participants, I would like to thank you warmly, and thanks also to everyone who was here. Thank you for the active discussion and the questions. And now I would like to encourage you all to be active in this issue, and I'm sure also the RDA can support the community here in trying to improve this proposal. So thank you very much.
Thank you.
And we have many thanks from the audience. Okay. So we will now end the session. Thank you all.